Good evening and welcome all the guests and dignitaries of the day. Before we start the program to be handed over to our Mr. Sudhir Misra sir, I take the pleasure of the presence of all the dignitaries of the day, Honorable Justice Mr. Sudhanshu Dhulia sir and Honorable Justice Sudhir Kumar Jain sir and Dr. Lalit Bhasin sir and Mr. Sumit Sen and Mr. Mohit Sarraf and all the guests who are present over here. I am Dr. Mohammad Salim. I am Director, Lloyd Law College, and we have built this college in 2003, and since then we have been trying to create legal education in the form of more and more practice-oriented and profession-oriented and practical-oriented. And we have, for the same reason, we have established this law school in the vicinity of the Delhi and NCR, Delhi in the NCR region. We are just 30 kilometers away from Delhi High Court, and we are just 31 kilometers away from Supreme Court of India. We are in the vicinity of 17 district courts of Delhi and in the proximity of almost all the central and state tribunals in Delhi. Since 2003, we are running this law school to establish this law school in a way which is most prominent, that students of our law school must have to learn the legal education in the form of better skill opportunities and better exposure, which is required for the law professional and legal professionals to cater to the requirement of their clients and the industry and the profession and the bar and bench both. We have established a lot of skill centers in our law school. Like, for example, we have established a trial advocacy center in which we are not only training our students inside the class, we are training our students inside the courtroom that we have built in our law school, in which a student is practicing the trial which is run in the district level court almost for 8 months. And they are doing their own case as a complainant, then as a public prosecutor, as an investigation officer, as a defense lawyer. They are practicing their own case for the period, for the duration of 8 months, and they are doing it in the form of a role play.
Justice Sudhanshu Dhulia has entered, sir.
Yes, sir. Yes, sir. We will start. We will hand over to sir.
We welcome you, sir.
Sir.
Good evening, everybody. I welcome Honorable Mr. Justice Sudhanshu Dhulia, Honorable Dr. Justice Sudhir Kumar Jain ji, Lalit Bhasin sir, Mohit Sarraf sir, Murari Tiwari ji, and all the other guests who are participating in this conference today evening. I have been asked to introduce my father, on whose name this mediation competition started 4 years back. My father was a teacher of mathematics, and later he also became a civil servant. And I was somebody who was always inspired by his lifelong passion for education and teaching. And he used to teach us when he will come back from office. He was somebody who was known as a mediator, as a civil servant. One of the early instances, which I remember very clearly in 1978-79, when we were 7-year-old, I remember CISF had done a major, almost like a revolt in a steel city of Bokaro, where he was city magistrate, and he managed to convince them to put all their guns down. All his life, he was interested to educate people around him. To us, he was always asking to read more and more. Once in his civil services days, he was posted as a district public relation officer, which was supposed to be a punishment posting. But he was so happy because he used to get 15 to 18 newspapers. And he will insist that all of us will read all those newspapers. And for almost 2.5 years, we were reading newspapers all the time. So this competition, which started in 2020, was just before the pandemic, was largely my tribute to him, who encouraged me to become a lawyer, become a problem solver, and to connect with the legal community right at the student age and ensure that more and more people benefit from the art of mediation, make mediation something which is a completely alternative dispute resolution. And I'm thankful to Lloyd Law College, Manohar ji, Salim sir, Iram, that today this international competition has gone to 30 countries More than 51 law schools are participating. More than 300 students deliberated over the problems for last 2-3 days. And for every passing year, we'll make it a more important competition. With these thoughts, I will call Manohar Thirani ji, the president of Lloyd Law College, who will also say a few words, and then we'll go to the honorable chief guest.
Thank you so much, sir. Let me have the honor to welcoming Honorable Mr. Justice Sudhanshu Dhulia, sir, Judge, Supreme Court of India, Chief Guest of the function. Our guests of honor, Honorable Dr. Justice Sudhir Kumar Jain, sir, Judge, High Court of Delhi, Dr. Lalit Bhasin, sir, President SELF and President Bar Association of India, Mr. Mohit Saraf, sir, Founder and Managing Partner, Saraf and Partners, Mr. Sumit Sen, Mr. Sudhir Misra, sir, Mr. Murari Tiwari, sir, Professor Dr. Salim, sir, Era Madam, Akle, sir, participants of the competition, eminent dignitaries, faculty members, and our very dear students. A very, very good evening to all of you. It is our proud privilege and honor to host the 4th edition of the S.K. Misra Memorial International Mediation and Negotiation Competition. And it gives me immense pleasure to welcome you all to this valedictory function. At the outset, I thank all of you for your contribution in making this competition a grand success. Lloyd is proud to be part of spreading the knowledge of mediation and negotiation among the law students throughout India. Today, alternative dispute resolution has become central to legal practice. Mediation and negotiation company is being organized by us to enhance students' client management skills, to better equip them at handling pragmatic problems by giving them an interdisciplinary outlook of approaching legal issues. By this competition, I'm sure that the participant students are provided with a platform, not only to on their mediation and negotiation skill, but also life skills of problem solving and decision making, as it provides insight into both life and profession. Lloyd has opened up a new Center for Arbitration and Mediation, which was inaugurated in December 22 by Honorable Mr. Justice Ravindra Bhatt, sir, Judge Supreme Court of India, to give exposure to our students in live cases under the leadership of Ms. Iram Majid, who is passionately building future mediators and arbitrators. We are extremely honored today by the gracious presence of Honorable Mr. Justice Sudhanshu Dhulia, sir, Judge Supreme Court of India, as our chief guest of the function. Lordship's presence here exhibits his passion and commitment for legal education. I sincerely thank your Lordship for sparing your valuable time from a busy schedule and gracing us with your presence as the chief guest for this very function. A very, very warm welcome to you, Lordship, on behalf of all of us. We are extremely thankful and blessed with the gracious presence of Honorable Dr. Justice Sudhir Kumar Jain, sir, Judge High Court of Delhi, as guest of honor. Honorable Justice is one of the most trained mediators, as well as a widely known trainers of trainees. Honorable Justice has conducted mediation in more than 12,000 cases in diverse fields. Justice, we are honored to have you here to deliver the address, and we are eagerly waiting to listen from you. I extend a very, very warm welcome to you from all of us here. A very warm welcome to you, Lordship. It's our honor to welcome our very old Dr. Lalit Bhasin, sir, President, Self-President of Bar Association of India. Sir, we are extremely grateful for your guidance, support, and your zeal for enhancing legal education. And we are personally thankful to you for always supporting our college and being an encouraging and motivating and blessing us along with Madhavan, sir. I extend a very, very heartfelt welcome to you, sir. It's my pleasure to welcome Mr. Mohit Saraf, sir, Founder and Managing Partner, Saraf and Partners. Very grateful for your advice and support for the competition. A very, very warm welcome to you, sir. It's my privilege to welcome Mr. Murari Tiwari, sir, former Chairman, Bar Council Delhi. Sir, we are very grateful for your presence here, and I extend a heartfelt welcome to you. A very, very warm welcome to Sumit Sen, sir, and our very dear friend, Advocate Sudhir Misra, sir. Sir has worked very hard to make this event happen. Sir, a cordial welcome to you, and thank you very much for giving us this opportunity. US Supreme Court Justice O'Connor once said, the court of this country should not be the place where the resolution dispute begins. There should be the places where the disputes end after alternate method of resolving disputes have been considered and tried. This holds especially true for the Indian legal system. There is a tremendous backlog of cases in our court, and this hampers the delivery of justice. If alternate dispute resolution methods are used effectively, then they can be a force for the good, and our cases can come down significantly. The participation of several universities from all over the region truly reflects the usefulness and relevance of the competition. As we could see, all the participating teams have sent their jewels, which led to a vibrant competition. I applaud the hard work put in by all the competitors and congratulate all for making it a success. It's my pleasure to welcome my faculty and my dear students who have worked day in and out for this competition, without whose cooperation this competition would have now been a success. With these words, let me welcome all of you to the fourth valedictory function of the S.K. Misra Memorial International Mediation Negotiation Competition. Thank you.
Ilma, I invite you to introduce our chief guest, Honorable Mr. Justice Sudhanshu Dhulia, Judge, Supreme Court of India.
Thank you so much, sir. Honorable Mr. Justice Sudhanshu Dhulia was born on August 10, 1960. Lordship did his earlier schooling from Dehradun, Allahabad, and Lucknow. Lordship graduated in the year 1981 and completed his master's in modern history in the year 1983 and LLB in 1986. Lordship initially practiced on the civil and constitutional side before the High Court of Judicature at Allahabad. He shifted his practice to the newly created High Court of the state of Uttarakhand at Nainital and was designated as senior advocate in June 2004. Lordship elevated as a permanent judge of Uttarakhand High Court on November 1, 2008. He took oath as the Chief Justice of Guwahati High Court on 10th January 2021. Lordship elevated as the judge of the Supreme Court of India and assumed charge on 9th May 2022. We are honored to have Lordship with us. I very humbly request your Lordship to kindly address the gathering.
Well, Justice S.K. Jain, Judge, Delhi High Court. Am I audible? Is it okay?
Yes, Lordship. Yes, Lordship. Yes, Lordship.
All right. Dr. Lalit Bhasin, who's former chairman, Bar Council of Delhi. Dr. Muhammad Salim, Director and Dean of Lloyd Law College. Mr. Sudhir Misra, Mr. Manohar Tehrani, Ms. Iram Majid, who is a practicing lawyer and also an honorary director of Lloyd College. And I'm told she's also associated with a lot of these institutions. Dignitaries who are here, ladies and gentlemen, and my dear fellow students. Sorry if I'm missing out of anyone, my apologies. When Ms. Iram Majid had come inviting me for this function, frankly, I was not even knowing that you have some kind of a competition in mediation as well, because I had heard about moot courts and all that, but this was new to me. It's good that new developments are taking place in this field. Ms. Iram had also given me her book on mediation. And then I realized what kind of a work she's doing. I mean, it takes a lot of effort in writing a book, which is a scholarly book on such a subject, and you know the kind of research you have to do. And then on top of it, you're also a practicing lawyer and associated with so many such institutions in the field of arbitration and mediation. So that's a good work. Keep the good work going. Now, when I've been told that there are about 50 or 51 teams which are participating in this competition, and which are from all over the country, but also from 4 or 5 different from outside countries as well, I'm told. There are participants from Malaysia, Singapore, Colombia, UK. So that's, I can imagine the kind of hard work it must have been taken from the organizers, the kind of logistics involved in it. You know, it's a great work, and the efforts which must have gone into it. So I wish you all the success. Keep the good work going. See, when I see of this mediation and conciliation and all these alternative dispute resolutions, mediation comes to me as some kind of a compromise which you reach. And there are, see, who are those people who come to finally reach a compromise through mediation? They are anyone who comes to that decision. It's a very mature decision, and there's a lot of wisdom also in it. There's always a beauty in compromise, because there are so many pitfalls to ordinary litigation. that a mediation is always welcomed. And this is my firm belief that people who finally, the parties, only such parties succeed, which are not only because of a successful mediator and the craft of a mediator, but ultimately the parties are those parties which are slightly more mature than other parties. This is my experience. I'll tell you one or two incidents. As a lawyer, when I was practicing in Allahabad, um, then a lot of dispute used to come. I belong to the hill area of Uttarakhand. So the pure civil matters in those cases, in the villages, a lot of them are regarding boundary disputes between one village and another. So there were 2-3 instances where I tried to mediate between the parties, between because they used to come, 10-15 fighting for their case, and another 10-15 were there with another lawyer. So I tried to mediate because I knew many of them. I didn't succeed because there's so much of passion involved in it. But there was one case where I tried to mediate and tried to. There were 2 judges. It was a matrimonial dispute, not even matrimonial. The husband and wife, they had not even filed for a divorce or even restitution of conjugal rights. They had a child, a 9 or 8-year-old son, and the fight between them for the custody of that child. They belonged to, both husband and wife belonged to, they are well off. The child was staying with his father in the hills, and the mother was staying somewhere in the plains, and she filed a petition for the custody. Now that was not being given to her, and she was there in appeal. So we tried, both the judges, we tried to, settle down the matter. The boy had also come with his father, and the boy, the father and mother, we had called them in our chamber. And I asked the boy, he's very intelligent. I asked him, where does he want to go? And initially he said, I want to go with both. I want to stay with both Papa and Amma. But then I said no, because that was not possible, no matter how much we wanted to. So when we gave her only one choice, with the father or mother, he said father. And he just hugged his father. And then it was pre-lunch session. Then we asked the parties to go to the market. You can spend some time together. You come back again. So when they came back again, post-lunch session, it's very touching. The wife said that I'm withdrawing my appeal. Let the child go with the father. So I asked her, why? Why is it so? Then she said, because I think my son is very happy with his father. It's as simple as that. And if he is happy, then that makes me happy too. So that, I think, was a very mature decision. This woman sacrificed her happiness for the happiness of her child. Now, normally what happens is that a compromise or a settlement doesn't take place for small egos, from some small issues. A successful media can break it, and that's the whole success. But many a times I find the entire attitude, the approach of the parties also in this very mature. Therefore, the work which is going on it should be encouraged. I'll tell you, I don't know who are in the audience because I can't see the youngsters here, but this story is for them, and then I'll try to end. And then my source, as usual, happens to be my colleague, Justice Ramaswamy, because he has many such stories. And this is about, why you should go for mediation, why you should not fight or not litigate too much. That kind of a lesson I find in this story. So what happened was that there were 2 friends. They started on a journey together from their village, and they were going to some place. So when they started their journey, the one man takes out 5 loaves of bread for the journey, and the other one takes 3. So they're going on a journey, then the evening sets in, and they say that let's take a rest. So they find a place, for resting, and then they stop there. They want to sleep. Before that, they want to have their dinner. So they take out the bread which they had purchased. As they're about to start their dinner, another person comes in. He says, a stranger. He says, "Can I stay with you here for the night?" They said, "Yes, welcome." Then they offer him the meals. So all three of them sit together. So what this man does is, who has got 5 loaves, he corrects all the 5 and 3 together and divides each loaf into 3. So 8 into 3 becomes 24. So 8 is given to each one of them, 8 pieces. They have their dinner, they sleep. And in the morning, the stranger who had come, he thanks them of the meals and for the night. And then he gives them 8 coins, silver coins or whatever. Say, "This is for you," and then he goes away. Now, the one who had the 5 loaves, he says, "Okay, I just, roughly," he says, "Okay, I had 5, you had 3, so I take 5 coins, you take 3 coins, and let's divide it." So the one who had 3, he says, "No. Once you have put 5 and 3 together, this is now a common mixture. Now you have to give me equally, 4 to you and 4 to me." Now there's a dispute. And they go to the Qazi. So when they go to the Qazi is a wise man. He tells them, "Look, there's no point taking up this litigation. I think it's a fair deal you have got. You take 5, you take 3, go away." So the one who had 3 loaves, he says, "No, I want justice," probably he said. So Qazi said, "All right, I'll give you justice." And then he finally decides. He said, the one who had 3 loaves will get only 1 coin, and the one who had 5 will get 7. The reason being simple, because the one who had 5, ultimately when it was divided, he parted with 7 loaves. And the one who had 3 parted actually with 1 once you divide it. So he was getting 3, now he got only 1. What I'm trying to say is, sometimes there is a kind of a justice in mediation also.
Yes.
One should stick to it and not take a litigation further. But unfortunately, this kind of a sense doesn't come easily to many of the litigants.
Yes.
And with the result, the litigation keeps on. So those who are in this field must be congratulated, because I remember when I was a lawyer in Uttarakhand, and this mediation, then Mr. Shriram Panchu had come at that time, and he had given a wonderful lecture on mediation and the kind of developments which is taking place and what is being done in this field. And in the end, he referred to a saying in Bible, which I must also say, which was clearly written, that blessed are the peacemakers, for they shall be known as the children of God. So those who are in this field are doing a very good work. I mean, I wish there would be some more time, and I wish I could participate more in such kind of events, because they are for the betterment of everybody. Because the pitfalls in the litigation are too many, and they must be avoided. Thank you so much.
Thank you, Lordship, for your kind words. And we are very grateful for your presence today in this function. And Your Lordship, we understand that you have a prior engagement and you took out time. And Your Lordship, we are grateful for your presence today. Thank you. Thanks a lot for your coming and joining us. We are now asking Shreya to come and properly introduce Honorable Dr. Justice Sudhir Kumar Jain, Judge, High Court of Delhi.
Thank you, sir. Honorable Dr. Justice Sudhir Kumar Jain is permanent judge of the Delhi High Court. He is an accomplished legal professional with extensive experience in the judiciary, as well as a skilled mediator and trainer. Dr. Justice Sudhir Jain was elevated as permanent judge of Delhi High Court in February 2022. Lordship has served in various roles throughout his career, including as an advocate, lecturer, and judge. His accomplishments in the field of mediation has been recognized by the International Mediation Institute, Holland, where he has been accredited as a mediator. Lordship is a trained mediator for mediators, and he has been trained in the ISDLS California and CEDR UK. Lordship has conducted mediations in about 12,000 cases and delivered more than 100 training programs to all the stakeholders. We are very honored to have Lordship with us, and now I very humbly request your Lordship to address the gathering.
Thank you, Madam Shreya, for giving such kind introduction about me. I am very thankful to you. My Lord, Honorable Mr. Justice Sudhanshu Dhulia, Judge Supreme Court of India, respected Dr. Bhasin, President SILF and President Bar Association of India, Mr. Sudhir Misra, Founder and Managing Partner, Trust Legal, Advocates and Consultant, Mr. Mohit Sharaf, Founder and Managing Director, Sharaf and Partners, Mr. Murari Tiwari, former Chairman, Bar Council of Delhi, Dr. Muhammad Salim, Director, Lloyd Law College, Shri Manohar Tehrani, President, Lloyd Law College, Ms. Daisy Pallavi, Student Convener, Ms. Iram Mazid, Director, Indian Institute of Arbitration and Mediation, Dr. Akhilesh Kumar Khan, Director, Admission and Administration, Lloyd Law College, Organizer of S.K. Misra Memorial International Mediation and Negotiation Competition 4.0 in association with Lloyd Law College, faculty, student, participants from India and abroad, other guests, ladies and gentlemen, good evening to all of you. I'm very thankful and extremely thankful to the organizer of this excellent event for conferring this honor on me to be the part of Valedictory program. I also take the opportunity to congratulate the participant and the winner of S.K. Misra Memorial International Mediation Negotiation Competition. I came to know the participating teams belong to prestigious college and university at national and international level. The organizer of this competition deserve every possible appreciation and applaud. I remember I also the part of the valedictory function on the last year in 2022. And this year I received the invitation from Dr. Muhammad Salim, and also before that a letter from Madam Iram Mazid to be the part of to be the judge of the final round of this competition, as well as to be the part as a guest of honor of this valedictory function. Me and Madam Iram Mazid has conducted many programs together in different parts of this country. I know she is very committed, dedicated mediator and to the cause of justice. I'm having very long association with her, so I can never say no to her. So on the request of Dr. Muhammad Salim and Madam Iram, I am very fortunate to be the part of this program. I have witnessed the final round of this competition. I was really amazed to see the performance of the participant and their commitment and their knowledge about the nuances of the mediation. I am sure that the future of the mediation in this country is in the now safe hands, and it is very bright future. And I am having every reason to believe that within the short span of time, the mediation will take its own way in India. And the presence of legal luminaries from across the world, including Mr. Sumit Sen, who was also one of the judges in the final round, and presence of respected Dr. Bhasin and other legal luminaries, is making this occasion very special and giving a message to the society at large that tomorrow belongs to the mediation, not to the litigation. We have to mediate, not to litigate. Dear friends, we know the traditional justice delivery system is coupled with procedural delays, which result into the piling of cases for judicial disposal, which may undermine the effectiveness of the justice delivery system in totality. It is already experienced that the disposal of pending cases in the courts of different jurisdiction is not possible within reasonable time, and this situation poses a big challenge for everyone who are associated with the justice delivery system. as per the constitutional mandate, the assurance of the speedy justice should be extended to the citizen. I remember the words of Honorable Mr. Justice S.B. Sinha. His Lordship is not more than a pioneer figure in the promotion of the mediation in this country. He used to say to us that the expectation of the speedy justice by the citizen of this country is governed by the mandate of Articles 19 and 21 and 14 of the Constitution of India. Now, coming to the alternative dispute resolution mechanism, which are clubbed with the procedural flexibility and divide of stress of a conventional trial, may prove to be an effective tool for providing expeditious resolution of disputes. The Parliament has already reintroduced Section 89 in the Code of Civil Procedure with an objective to introduce ADR, including mediation, formally in the legal system. The Supreme Court in Salem Advocate Bar Association case has already upheld the constitutional validity of the Section 89 and also observed that the resort should be made to the alternative dispute resolution mechanism to bring an end to the litigation at early stage. The Honorable Supreme Court also highlighted that in certain countries, over 19% of the cases or disputes are settled out of the court by the use of ADR. Now, dear friends, as per the mandate of Section 89, the mediation has become a legally recognized way of dispute resolution. Before my talk on mediation, a little talk on mediation, as Honorable Mr. Justice Dhulia has shared his experience about the mediation, I still remember by the use of mediation. About 15 years back, I still remember I partitioned a property just measuring 25 square yards among the 7 claimants without physical partition of that property and without disposing of that property to the sale. All the 7 claimants, they went happy after their settlement. It can never be possible. I still remember in another case, a complaint under Section 138 filed by a bank against a professional chartered accountant who has taken the loan from that financial company bank. And ultimately what they have settled is that the financial company, that is the bank, has given the employment to the accused who was a qualified chartered accountant in the bank to avail his expertise in the financial issues, with the condition that some part of his salary would be taken, would be adjusted towards the repayment of the loan amount. Kindly see the innovativeness and the creativity which involved in the mediation. I can share hundreds such examples. In one case, I still remember, in a labor management dispute, the management has agreed to provide free education up to the 12th standard to the daughter of the workman. She was good in study, but the workman, due to the poor financial condition, was not able to provide education to the daughter. To see the beauty of the mediation. Dear friends, we know the mediation resolve dispute between the parties by direct communication, as we have witnessed in the morning session, in the afternoon session, with communication and negotiation with the opposite party with facilitation of mediator. The mediation is quick, private, fair, and inexpensive, and is a different paradigm from the traditional litigation, which focuses on the win and lose result. Mediation focuses on the direct collaboration and communication with the objective of win-win situation with the mutual acceptable solution for the contesting party. What I have experienced in my career as a mediator, the mediation is a democratic way of dispensation of justice, which is coupled with the direct communication between the parties, generation of option, exchange of information, understanding the underlying interest of the parties, anger management, which is totally contrary to the litigation system. And out of my own experience, I can say the mediation is a definite journey from dispute adjudication to dispute resolution, from confrontation to collaboration. It is not compromise, but it is a collaboration, and from past to future, and from negativity to the productivity. Mediation has now internationally accepted as a tool of dispute resolution, as large number of countries have already adopted provisions for resolving their dispute through mediation. as all of you must be aware that India has already approved the signing of the Singapore Convention of Mediation, formerly the United Nations Convention on International Settlement Agreement, in the month of July 2019. Now, with the passage of time, since the incorporation of Section 89 in the year 2002, we started mediation at the local level, then national level. Now, India, after signing the Singapore Convention, is marching in the field of international commercial mediation. As you must be knowing, at national level, the many positive steps have already been initiated to introduce mediation in the legal and justice delivery systems. The legislature has already introduced mediation in various statutes. For example, Consumer Protection Act, the Commercial Courts Act, Real Estate Act, the Companies Act, and many other acts also. And many, the public undertaking has also now planning and proposed to resort to mediation to resolve and to address their internal dispute also. As all of you must be aware that the Parliament is also in the process of enacting Mediation Act, which would give a definite direction for implementation of mediation in this country at institutional level. The Supreme Court of India has also constituted Mediation and Conciliation Project Committee, MCPC, on 9th of April 2005, which started or initiated a pilot project on judicial mediation in one of the district court in Delhi. And in Delhi District Court, I think 6 or 7 mediation centers are now functioning. And I'm very delighted to inform that in Delhi Mediation Center, which are operational in Delhi District Court, more than 2.5 lakh cases have already been settled by the process of mediation to the satisfaction of the contesting party. I remained judge in charge of the mediation center for a long period. So I can say with my own experience, out of my own experience, how the mediation is now accepted by the different stakeholders of the justice delivery system, including advocate, judicial officer, judges, government agencies, and most important, the litigants. But despite the grand success in the field of mediation, still we are facing many challenges to implement the mediation. Still there is apprehension about the future relationship between the mediation and the adjudication among the different stakeholders in the justice delivery system. Mediation is considered to be a compromise with the settled values and principles of the justice delivery system. Introduction of the mediation in judicial system, selection of the proposed mediators and their training in concept and techniques of mediation, establishment and management of mediation center is a very big challenge, how to manage a mediation center. Because I remained the judge in charge of the mediation center for almost 7 years. So I can say it is a great challenge throughout the country. Then again, the referral of the suitable and adequate cases for mediation, and most important, the awareness about the benefit and utility of mediation and how to generate, how to develop the credibility and acceptability of the mediation. They would be the different and apparent challenges in the implementation of the mediation. In future, the upgradation of the mediation practice and propagation of the mediation would be the big challenges to address and to counter. However, I can say with authority and lot of pride on my face that mediation has already made strong inroads in justice delivery system. The future belongs to the mediation. And I hope and believe that this program is a very positive step in generating awareness about the mediation, coupled with the negotiation in future legal generation. I use the word future legal generation because in the afternoon session, I witnessed how the 6 participants with lot of enthusiasm, commitment, preparation, they have participated in this final round. It was very difficult to declare one of them as the winner of the program. The fight was so tough among them. And this program definitely would develop a settlement culture at national, at international level. I once again extend my sincere gratitude and thanks to the organizer of this event, and more so to making and considering me a suitable person to be the part of this valedictory function. I always cherish my long relationship with Lloyd Law College, which would continue in future also. I hope so. Thank you very much and good evening to all. Namaskar.
Your Lordship, you have mentored us. You have mentored this competition also. You have blessed us and you continue to bless it because you are somebody who we all look up to for mediation. With this, I now invite Ilma yet again to introduce our guest of honor, Dr. Lalit Bhasin, the Bhishma Pitama, the biggest lawyer in my understanding, who is the biggest mediator also in my understanding in the legal fraternity between all the warring groups. And he's the president of SILF, he's president of Bar Association of India. All yours, Ilma.
I am sorry to interrupt. I think Dr. Lalit Bhasin recently completed 75 years in the practice. And I was the part of that celebration also.
Yes.
I attended that function.
Thank you, sir. Dr. Lalit Bhasin started his law practice in 1962 and has developed Bhasin and Company as one of the largest law firms in North India. His areas of specialization includes aviation.
I think we can do away with the introduction. Please. Thanks a lot.
We are very grateful.
Sudhir Misra and Honorable Justice Sudhir Kumar Jain, they have already said so much. You see, although very in short words, but brevity is an art. They have conveyed everything about me. Therefore, let us not add to that. Honorable Justice Dhulia, Honorable Justice S.K. Jain, that is Mr. Sudhir Kumar Jain, three persons who are responsible for having this event organized. That is my friend, Mr. Sudhir Misra, who is always motivating and moving, you see, the noble causes. He fights for them, he propagates them, and then he ensures good participation by the younger generation. That is Mr. Sudhir Misra. And Mr. Manohar Thairani, I have had the privilege of knowing him for, I think, nearly last 2 decades in my association with the Lloyd's Law College and various competitions and other events which were organized by Lloyd's Law College, along with my dear friend who is no more, that is Professor Madhav Menon. So he's one person who is always, trying to educate the younger generation, whether they are law students or they are young lawyers. And then, of course, the third person responsible is Professor Muhammad Salim. Again, I have had the privilege of knowing him, accepting his various invitations, and how he organizes these massive events where you see about more than 50 teams are participating, along with Dr. Akhileshwar and other members of his team. Then I also see my dear friend, Mr. Mohit Saraf. Mohit represents, you see, the emerging law firms of the country, young law firms, at the same time, very mature law firms. And with his expertise in the field of commercial laws and collaboration, international transactional work, I am sure Mr. Mohit Saraf will be able to contribute. And also my friend, Mr. Murari Tiwari, who had succeeded me as chairman of the Delhi Bar Council after about 30, 40 years, because I was the chairman in 1973 till 1975. And of course, we have heard a lot about the lady Iram Majid. I think she has worked effortlessly in making this event happen. I have heard about her background, that she promotes mediation and settlements and all that. It's a very noble cause. I also noticed that the knowledge partner is again a young law firm, Newman Law Offices, under the leadership of Mr. Arush Khanna. All the faculty members, all the participating teams, and my dear students, I bring to you greetings from the Society of Indian Law Firms, from the Chartered Institute of Arbitrators, from the Bar Association of India, and various other organizations which I happen to represent. This event is in the memory of a noble personality, that is Shri S.K. Misra ji. And it's very thoughtful on the part of Mr. Sudhir Misra to have put in place. You see this every year. This is the fourth edition of this. So, and I'm sure that this will contribute significantly with the help of Professor Manohar Therani and Professor Muhammad Salim. I would like to quote none other than Honorable Justice Krishna Iyer. Way back in 1977, in his inimitable way, Justice Krishna Iyer expressed what is better, litigation or settlement. And this is, I quote him, a legal adjudication may be flawless, but heartless. Please mark the words. A legal adjudication may be flawless, but heartless, but a negotiated settlement will be satisfying, even if it departs from strict law. This is coming from one of the greatest judges of the Supreme Court of India, one of the greatest jurists you see that we have produced. He says that a negotiated settlement is satisfying even if it departs from the strict rules of law. That is what we have to aim for. And why Justice Krishna Iyer was saying that? He was a great scholar also. He knew about the Indian background. Indians, right from ancient times, from the times of Manu Smriti and even earlier than that, we always believed in consensual form of administration of justice, not the adversarial form. This adversarial form has been a gift from the British, you see, of creating a 3-4 tier of court proceedings, starting from the lowest and then going right up to the Supreme Court. In their cases, it used to go right up to the House of Lords and Privy Council and all that. So the same system has been brought in here. Even during the Mughal times, we have heard, I think some of you must have heard, Adle Jahangir. Adle means justice, not law. Emphasis was on justice, consensual form of justice. That is what you see has been our culture. Therefore, consensual form, or to use the modern terminology, mediation, is the answer. We have, and it is not disputed, even the Honorable Chief Justice has said, we have nearly 5 crore cases pending all over the country. The Honorable Chief Justice very recently spoke at a event which was partly organized by me also. He said that we are bringing in digitization and all those things. That is very good. But what are the steps being taken to reduce this notorious laws delays of 5 crore cases which are pending? Are we giving justice, you see, to the citizens of this country? Therefore, what is required is a change in the mindset of our people. And that is where Mr. Manohar Therani, the role of the law school comes in, that try to inculcate in the students this change of mindset from litigation to developing negotiating skills. Negotiating skills, you see, should be one of the subjects which should be taught in the law schools. That how do you avoid disputes? How do you negotiate settlements? So that is a very important factor which the law schools, you see, they have to take a lead. Otherwise, this 5 crore may become even 10 crore cases in the next 10 years. And where is the administration of justice then? Therefore, the answer is develop this negotiating skill into mediation. Mediation, of course, our own High Court, Delhi High Court has taken a lead in this, much ahead of other high courts in setting up special mediation centers. But then that is at a very minuscule scale. It is just how much work, you see, how much High Court can contribute towards that. Whatever cases come to them, the High Court honorable judges, they refer it to the mediation. But that is not even, you see, a minuscule number of disputes which arise daily. Therefore, what is required is a change in the mindset, developing the negotiating skills. I am known to be an incorrigible champion for settlements. Even Moise Saraf recently introduced me that Mr. Bhasin stands for settlement of disputes. But I take it as a privilege, you see, that whenever I do appear, either before the Honorable Supreme Court or before the Honorable High Courts, they say, okay, Mr. Bhasin is there, possibly there could be settlement of the cases and all that. That sort of a thing has to be developed, you see, in the legal profession, but that has to start from the law schools. Therefore, it's a great responsibility. And Mr. Tharani and Mr. Sudhir Misra, what I suggest to you is you should also involve the in-house counsel, the general counsel as participants, because big commercial disputes can also be resolved by mediation among the in-house counsel of the disputing parties. So they should also be brought into the picture, as also some NGOs which are doing great work. Mr. Sudhir Misra knows about these NGOs. Actually, his trust law, it's a law firm, but it is virtually an NGO for providing, you see, different services to the society at large. Therefore, try to involve these people also in your process of promoting settlements, because I believe, and I always tell my juniors, my friends, you see, who have been with me in my 61 years of my professional life, that a bad settlement is better than successful litigation. Please remember that. A bad settlement is better than successful litigation. These days in litigation, actually no one wins. Both the parties end up losing, at least in terms of money. Lakhs and lakhs, and if multinational company, then crores of rupees. That is good for lawyers, but bad for the country, bad for the economy of the country, because no one would then like to invest in India. No foreign country, you see, investors would like to invest in India if the dispute resolution process takes, you see, 10 years, 15 years and all that. Therefore, try to promote the spirit of settlement, and a big responsibility lies on the law schools. So I earnestly appeal to you and to all the teams which are participating, because they must have been accompanied by senior faculty members, to please inculcate this feeling of settlement of dispute among the participants. I congratulate not the winner, not the runners-up. I congratulate all the teams for having participated in this great event, which I'm sure will lead to many more, to create that feeling among the people that, okay, let us talk. Let a dialogue be there, not adversarial system that, okay, let us go, I'll see you in the court. That sort of a thing has to be dispelled completely. So I thank you.
Thank you.
Mr. Sudhir Misra ji and Mr. Manoj Tharani and Professor Salim, and the honorable judges, particularly Honorable Justice Sudhir Kumar Jain ji, for hearing me out on this very important issue. Thank you very much. Thank you.
Thank you, Dr. Bhasin, for your kind words. And before I come to the next speaker, the guest of honor, Mr. Moise Saraf, before you introduce also Shreya, he is the only lawyer who is a Shaurya Chakra awardee. And he, in my understanding, is one of the biggest corporate lawyer, first generation lawyer, my inspiration. Yeah, Shreya, you can introduce him.
Thank you, sir. Mr. Mohit Saraf is founder and managing partner of Saraf and Partners. Having 3 decades of rich experience across all major practice areas, he is the co-founder of Luthra and Luthra Law Offices and was the head of all its corporate practices from its inceptions in 1999 till October 2020. He has been invited by the National Judicial Academy, Bhopal, to conduct training organizations programs for higher courts and commercial courts. He is the member of FICCI and co-chair of corporate law committees, co-chair of private equity and venture capital committee, member of FICCI steering committee, and member of National Executive Committee of FICCI. We are very honored to have Sir with us. And now I would request Sir to kindly address the gathering.
Thank you, Shreya. Justice Dhulia, Justice Jain, I think the entire experience of 12,000 mediation cases is inspiring. Dr. Bhasin, who is just not the Bhishma Pitama of the Indian legal industry, but my personal mentor. Mr. Therani, Iram Masjid, I've known her for a long time. Dr. Muhammad Salim, dear friend Sudhir Misra, and all other people on the dais, as well as students for participating. I think everybody, Dr. Bhasin, Justice Jain, Justice Dhulia has really said that really mediation is the way to go forward. Personally, particularly in small disputes, particularly in, I would say, matrimonial issues, ego issues. And also, I think Dr. Bhasin mentioned about the opportunity on the commercial side, commercial dispute. Today, if you look at litigation and arbitration, majority of disputes are commercial disputes. Either the government is a litigant or private parties is the litigant. And therefore, the effective success of mediation and negotiation would be, how do we succeed in this environment of business? And I maybe being a commercial lawyer, as Dr. Bhasin said to me, I think I must give that perspective, which is very important. Today, if you look at Indian economy, we are a $3.2 trillion economy. And I think if you look at the World Bank report, everybody, you look at it, that they all say that India in next 10, 15 years will be a $10 trillion economy. That means moving from $3.2 trillion to $10 trillion. And that would require an investment of $3.5 trillion. So therefore, what we are looking at is huge amount of commercial disputes, whether it's a construction contract, whether it's an infrastructure contract, whether it's a shareholder dispute, whether it's a bid-related dispute. So you go to huge amount of this. Clearly, I think the Chief Justice is working very hard in creating capacity. But clearly, as Dr. Bhasin said, that the pending cases are 5 crores. And if the economy moves from $3.2 trillion, remember this $3.2 trillion we achieved in 75 years of our independence. So if you move from $3.2 trillion to $10 trillion in 10 years, 10, 15 years, you can imagine the capacity you require in the judiciary. So clearly, that capability and that ability to create that much of bandwidth will be lacking. And therefore, clearly, I would say alternate dispute resolution is the way forward. I think there is no case, nothing to discuss on that issue. That is straightforward. But I would look at it like, why do India fail on really big commercial disputes getting resolved through mediation? And why does different parts of the world succeed? And I will bring out 2-3 issues which are important so that this actually becomes a way of life in commercial dispute, including the government disputes. So therefore, I will bring 3 aspects. One important aspect is where in India, if you look at our enforceability of contract, we are at 163 out of 190 nations. So we are at the bottom 25. So if you are at the bottom, now mediation typically succeeds in countries where disputes get resolved very quickly. Any country where disputes get resolved over a long period of time, there is an ability for people not to resort to mediation. I tell you why, and I'll explain to you so that you are able to appreciate, and therefore this is a major thing which requires to be improved. if you look at cases in India, at the first instance, the World Bank says that India takes 1,400 days to resolve dispute at the first instance. Compare it with Singapore, it takes 165 days. So if you are disputing and litigating in Singapore, and you know your case, that it's a good case, average case, therefore the chances of negotiation and mediation becomes very successful, as what Dr. Bhasin said about Justice Krishna Iyer's words, because that is almost coming there. But if you look at the Indian situation, often one party understands that he has a great case. The other party understands he has a weak case. But he understands that if you litigate in India, you get a 1,400 days free ride not to pay money. And if you look at capital cost income, if most corporates in India have a capital cost of 12-15%. So therefore, if you get a free ride for 1,400 days, so virtually you make, like if you have to pay 100 crore and you litigate, so you actually save 60 crores on interest cost. Now, if you're saving 60 crores on interest cost on a litigation, which is obviously a frivolous litigation, or litigation which do not have that much of substance, then the chances of mediation and negotiation succeeding is less. And that is an important part. So therefore, enforceability of contract needs to be improved significantly for mediation to succeed, particularly in a commercial dispute, because often commercial parties use litigation as a delay tactics. One party often uses this as a delay, and often because of the bandwidth issue, you're able to live on an injunction. You get an injunction for a higher court, and then you stay with that. So that is one part which requires significant change. The other thing which requires significant change are certain parts of substantive Indian law. Because I think particularly Section 73 of Indian contract, even if a party is intentionally breaching a contract, you cannot order punitive or exemplary damages. And therefore, again, the compensation payable or the damage payable is governed by Section 73, which is very, very limited. And that is one important aspect in any country where mediation and negotiation succeeds, particularly in disputes. The downside of not negotiating or not settling is very high. And right now, because of Section 73, the downside is very limited. The second thing is also about a concept of liquidated damages. Even if there are liquidated damages agreed in a contract, which in most cases it is agreed, but courts look at it that whether there is a loss actually suffered or not. And if the loss has not been suffered, then the liquidated damages amount becomes a ceiling amount, not the actual amount which is to be paid. So that's the second thing. And therefore, there is a lot of requirement to move jurisprudence on this issue. The third issue is also about the arbitration and litigation of paying the cost, the interest cost. Now, that is again an issue of lot of arbitrariness, or it moves from one court to the other court. Again, I would say typically the court should award interest. What should be the cost of borrowing of the person who's supposed to pay earlier? If the cost of borrowing is 15%, and if you award 8%, he has made 7% money. Now, if he makes that 7% money, let's assume a corporate cost of capital is 15 or 18%, and you are awarding 8% for delay payment, then he's clearly making 10%. And therefore, he will never agree for mediation. So therefore, we have to create commercial compulsion to favor mediation. And that requires us changes in certain substantive law. And obviously, the last thing we talked about is that institutional framework, which is at the parliament level, needs to be implemented. Because if once that happens, that also will give a lot of sanctity. And I think important thing for me is that really, and from the government perspective, often government is the biggest litigator in India. Mediation is a non-starter with government, because the minute you get into mediation, there is an assumption of corruption or assumption of something not right. So that's the big problem. And I think with the institutional framework of mediation, and I would say a lot of thinking, and Dr. Bhasin has to lead there, that a lot of efforts have to be made, particularly for senior bureaucrats to understand that this is the way to go. And if there is a mediation, we should not raise questions. We can get more senior people involved. But once the mediation is decided, once it's done, then the parties who are participating in the mediation, you should not believe that there was influence, undue influence. I think with that, I would say that that is really the right way, because commercially, clients who are chasing $1 billion of recovery will always go to something which will benefit them. And right now, because of these substantive law issues, sometime mediation, basically this is really creating a problem in getting a lot of our commercial disputes resolved through mediation.
Thank you, Mr. Saraf, for your amazing words and putting the corporate perspective about the entire mediation thing. It will surely upgrade this entire debate about how much mediation should be part of the mainstream litigation scenario or resolving the disputes. Our next speaker is the Bar Council representative, ex-chairman of Delhi Bar Council of Delhi, Mr. Murari Tiwari. And I encourage Srishti to introduce him.
Thank you so much, sir. Mr. Murari Tiwari is a former chairman, Bar Council of Delhi. He is a law graduate from Campus Law Center, University of Delhi, and joined the bar in the year 1991. He was elected as the additional secretary, Delhi Bar Association, Tees Hazari Court in the year 1999 for consecutive terms. Mr. Tiwari has been a member of Bar Council of Delhi for 3 consecutive terms since 2003. He was elected as the Honorary Secretary, Bar Council of Delhi for 2 terms in year 2010 and 2012 respectively. We are honored to have you with us, sir. I humbly request you to kindly address the gathering.
Thank you. Thank you. Whether I am audible?
Yes, you are.
Honorable Mr. Justice Sudhanshu Dhulia, Judge Supreme Court of India, Honorable Dr. Justice Sudhir Kumar Jain, Judge Honorable High Court of Delhi, Dr. Lalit Bhasin, the President, SILF, President Bar Association of India. He has a long list of introductions. Dr. Sudhir Misra, Mr. Mohit Saraf, and Dr. Muhammad Salim, and Mr. Manohar Tharani, and Dr. Abhishek Kumar Khan. The credit goes to Mr. Sudhir Misra, who has got me connected today. And I must share with you that I had been listening all speakers very carefully. I heard Honorable Mr. Justice Sudhanshu Dhulia. He was sharing his experience about mediation. Similarly, I experienced about mediation since the day of my joining in the bar. In the year 1991, I joined bar, and even at that time, I noticed that in the courts, with the help of the judges, the lawyers were being a good mediator. In those days, no particular law or rules were made in our time when we joined the bar regarding mediation or conciliation, or alternative methods were not there at that time. So what was being done, that the honorable judges were asking the lawyers that why this matter can't be settled. So even at that time, the lawyers were helping parties and we were getting settled the matters. So today, the good thing is that the law regarding mediation has been evolved in many folds, and almost in all sector of litigation, it has been introduced. It may be in proceedings of CPC or Arbitration and Conciliation Act or Companies Act, even in Consumer Protection Acts. More particularly in Hindu Marriage Act, the rules have been framed to go for mediation whenever there is any petition for dissolution of marriage or any dispute relating to matrimonial life. Then in commercial suits, it has been become almost a mandatory rule that first of all you should go for mediation, then you come to court. So I am very positive about mediation. Mr. Sudhir, I must share with you that we have noticed that a lot of things have been changed in mediation. Thousands of matters are being settled through mediation. I must share with you that Mohit Saraf and me, we had been from the same batch. We graduated in law from Campus Law Center in the same batch. So he got involved in the corporate sector, and I was confined to pure litigation at bar. So the things were entirely different. But he was right to a certain extent about commercial suit. But at the same time, I noticed he must be dealing with the higher side or the matters relating to a very high, higher side amount that may be difficult for settlement in mediation. But in normal suits in courts before the Honorable High Court of Delhi, Mr. Sudhir, I have noticed that many matters are being settled in mediation, in commercial suits also. So we have to be very positive. And the very good thing is about Dr. Muhammad Salim, that he has introduced this topic to the students of law. Today, the audiences or participants are the students of law who are introduced to law. And very good thing is that, Sudhir, that they are being taught about mediation. I think it is an exceptional, competition which has been organized by Lloyd Law College, and I'm very happy. And I know that the credit goes to Sudhir, and you must have coordinated with Salim, Mr. Salim, Dr. Salim, and you both have organized a very good program. And I think it will be very fruitful for the students who are joining bar, because it takes many years to understand about the mediation and conciliation. So in case we are introducing this topic to the students who are coming to our profession, so I think they will understand it in more better way. Yes. So I was very happy listening Dr. Sudhir Jain. He had been our senior in Campus Law Center at the same time when he was pursuing LLM, and I had always his guidance. And I have seen his working as a mediator in this Jari Court or even before the Honorable High Court of Delhi. And we are proud of him that he has settled almost more than 12,000 cases in mediation. It's a matter of great honor for us that he has done a remarkable job. So I always give him a lot of credit that he has a lot of patience. Even in personal life, I have seen him that he's a very cool person, and mediation requires a very cool person who can talk to both the parties comfortably and who can reach out to the dispute. I was in agreement with Dr. Bhasin. He rightly said that he is my forefather in Bar Council. Like 30 years before, he had been Honorable Chairman of the Bar Council of Delhi, of which I was the chairman. So I always regard him like a guardian. And he was rightly saying that whenever any matter is settled before the mediation, in that case, both the parties feel that both have won the case. Yeah. Otherwise, Sudhir, even after passing of a decree at a very early time, it doesn't, satisfy both the parties. But when matter is settled before the mediation, and I always suggest parties also that in case of compromise of a matter, both the party will feel that they have won the case in their own way. So really, I was also enlightened by the views of the speakers. But at the same time, Mr. Sudhir, I must share that the participants are very important, who are the law students who participated in this competition. And the important thing was that they worked hard, they deserved congratulations, and I congratulate them and I welcome them because many of them must be from the final year of their law courses also. So I am here to welcome them in Bar Council as well, that in the month of May, April last or May or June, they will have their result of final year. So I am here to welcome them in profession. And I appreciate Dr. Salim that he has got them educated about mediation. So their temperament will be entirely different when they will come to the bar. And one more thing I would like to share. The feedbacks are with me. Dr. Mohammed Salim, I must share with you that you have got a good name of your institution in CCS University. That is a very good thing for you, for your faculty, for your management. And I would like to congratulate Mr. Tharani also, because you people are working hard. Otherwise, in Bar Council, we always look at a student with an idea that whether he has gone to college or not. But when the question comes about Lloyd Law College, so then we look at differently at the student, and we feel that in case he has got education from this institution, so he must have studied law very properly. And today's program is one of the example. I never heard that any law institution had organized this topic and they got educated their students. So the outcome is that we have to be very positive. Slowly, laws are evolving and the rules are also being framed for mediation. The only difficulty which I am finding that whenever there is any settlement in mediation, then there is, there is some problem in execution of those, final compromise deeds which are being passed by the negotiator or counselor or in mediation. So I believe that in a very short time, there will be some rules with regard to execution of the settlements which would arrive by mediation. And there will be some sort of execution proceeding also. So with the core of my heart, I want to congratulate Mr. Salim and Sudhir Bhai. I am always, here to welcome you, and I appreciate your efforts that you are making all efforts to connect all legal luminaries on one platform, and I appreciate your efforts every time. Thank you, your team. Thank you to the organizers. I am very happy, and I would extend my all help in future as well. Whenever you will ask me, I'll join you. Thank you very much.
Thank you, Mr. Tiwari, for your kind words. And now we are just 5 minutes away from the result. Daisy, run through your event report.
Sure, sir. Good evening, everyone. Today, I'm overwhelmed to present the event report and mark the end of this long journey of the 4th edition of the prestigious competition, SK Misra Memorial International Mediation and Negotiation Competition. What is success? I think it is a mixture of having a flair for the thing that we are doing, knowing it is not enough, that we have got to have hard work and a certain sense of purpose. We began this journey in 2020 with the first edition of the SK Misra Memorial International Mediation and Negotiation Competition. We received 30 provisional registrations, out of which 13 teams participated in the same. We had the support of our mentors, trust legal advocates and consultants always with us. This competition in its first edition shared among the winners prize money of worth rupees 50,000 INR. From second edition, we had converted this competition into online mode with a good participation from global teams. In the 4th edition this year, SK Misra Memorial Mediation and Negotiation Competition 4.0, we have achieved 475 plus provisional registration and shortlisted 100 teams across 10 countries like UK, Malaysia, Sri Lanka, Singapore, Bangladesh, Indonesia, Nigeria, Nepal, Argentina, and India. Organizing 100 teams, written and oral rounds, competition in 3 days was a huge challenge. 4th edition of this competition shared among the winners the prize money of INR 03 lakh and equivalent to USD. We also have awards of all categories and all rounds and levels in this competition with the aim to show our appreciation to the hard work of participants in the field of mediation and negotiation. Our objective of this competition is to give alternative dispute resolution a platform to reach to the young lawyers on a scale that create vibrancy in the legal fraternity so that every dispute has a fair take to get resolved with fewer expenses, time, and frictions. We have organized a workshop for all the participating team on mediation, negotiation process, and skills on 24th February 2023. The workshop witnessed the presence of global mediation experts like Ms. Delcy, founding partner, Australian Dispute Center, Ms. Kathleen, mediator, trainer, consultant, author, and advocate from USA, Mr. Do Kyung Kim, IMI certified mediator and mediation advocate, Japan, Ms. Iram Majid, honorary director, Lloyd Law College, chairperson, Lima, director, AppCam and IIM, and Ms. Kainat Bundir, corporate lawyer at Shardul Amarchand Mangaldas. We had a panel of exceptionally proficient 100+ judges judging throughout this global competition. The judges from Coimbatore to Scotland and from Canada to Taiwan to Germany. We were supported, guided, and mentored by the best professionals and experts in the field of mediation and negotiation around the world. Our efforts have been recognized and appreciated by Mr. Ravi Shankar Prasad, Honorable Former Minister of Law and Justice, Union of India, and Mr. R. Venkataramani, Learned Attorney General of India. On a high note, this is where we are right now. Not because we pulled through such an exceptional competition, S.K. Misra Memorial International Mediation and Negotiation Competition 4.0, but because of the wisdom we had stemming through S.K. Misra sir's memory, and with the support of Mr. Mohit Saraf, Saraf and Partners, Mr. Arush Khanna, Newman Law Offices, Mr. Zulfikar Memon, MZM Legal LLP, Mr. Saket Shukla, Phoenix Legal, Dr. Anurag Batra, BW Legal World, and Mr. Sudhir Mishra, Trust Legal, with their presence and involvement throughout this event. We have an immense and incredible technical support, guidance, and mentoring by Ms. Iram Majid, Director, IIM and AppCam. Our supporting partner, BAIAC, PMN, IDRRMI, HKIMC, AIDRN, International Professional Advocates Association. I'm thankful to all the participating teams from around the world for a splendid show of courage, potential, proficiency, discipline, and skills in the mediation and negotiation competition. We welcome team from your law schools again. The finals have witnessed the competition from among the teams of Singapore Management University, Jindal Global Law School, School of Law, Ninma University, and Symbiosis Law School, Pune. My heartiest congratulations to all the finalists and the upcoming winners. Thank you all, and I hope to meet you all in March 2024.
Okay, thank you, Desi. Before we bring Iram Majid, who will announce the results, let me tell you, she's the shooting star of mediation world for India. And the kind of grace she has when she wrote her book, Mediation, on mediation law, and I had the pleasure of reviewing it for Business World. I saw the galaxy of Honorable Supreme Court judges and Delhi High Court judges who came and shared the dais with her, blessed her. She is, for me, an example what a evolved person should be, what a youngster should be, how aspirational she is and how giving she is. All the problems, all the questions, all the mediation challenges she was framing. And this last 4 years has been a testament to the fact that I've seen a young woman, Iram Majid, how she single-handedly lifted this program. Iram Majid, the floor is yours.
Thank you so much, Sudhir sir, for this kind introduction. So with this, I will not be stand in between the result and the participants. So this is the most exciting segment of the entire competition. And the finalist must be skipping one beat. And if it's so, say this is no wonder. So I would like to start with a couple of quotes. The price of success is hard work, dedication to the job at the hand, and a determination that whether we win or lose, we have applied the best of ourselves to the task at hand. In the life, winning and losing will happen both. What is never acceptable is quitting. So with this, would like to announce the award. So we have this time 13 categories. So I would like to start with the best mediation plan. So the best mediation plan goes to Yeb and Ling Chrissy, Singapore Management University. Congratulations. Best negotiation plan. We have Mr. Imad Imran and Amani Miskin from Royal Institute of Colombo. Thank you so much. And next award is Best Opening Statement Mediator. The award goes to Kashish Oram from National Law Institute University.
Arey yaar.
Congratulations. Another category is Best Opening Statement Negotiator Team. The award goes to Rohan Tripathi and Laksh Sharma from Maharashtra National Law University, Mumbai. Now we are coming for the best teamwork between client and counsel. And the award goes to Mr. Pranshutosh and Khushi Gandhi from the University of Petroleum and Energy Studies, UPS. Next award category is Best Creative Solution. And this again goes to Imad Imran and Amani Miskin from Royal Institute of Colombo. The next category of the award is Best Relationship Building with Other Team. And the award goes to Aditya Pandey and Shri Ballabh Sarthak Pathak, Chanakya National Law University. The next category is for Best Acknowledgement of Cultural Differences. And the award again goes to Imad Imran, Amani Miskin, Royal Institute of Colombo. And we have another category, that is the best performance for the first time participating team. So in this we have Shehan Daniel, Imad Imran again, and Amani Miskin. So now the time is the most critical award, I must say. It's the best negotiation team. The award goes to, any guess?
Oh.
Okay.
It was a flip of a second.
So before I will say the best negotiating team, let me say the runner-up first. So the best runner-up for the negotiating team is Paritoshika Singh and Ishita Mukherjee.
Oh,
The Global Law School. And the best negotiating team is Andre Luban and Fed Yo from Singapore Management University. And the best mediator. Before that, again, I would like to say the runner-up first. So the best runner-up for the mediator competition is Sanskriti. From Institute of Law, Nirma University. And the final award is the best mediator, everybody knows, Shri Madhura Srinivasa from Symbiosis Law School, Pune. I wish I could have more awards to give you, but these are the 13 categories which we have allocated. So all are finished. So over to you, Sudhir sir.
Thank you, Iram, for such a wonderful entire thing is so overwhelming. It's such an amazing thing to see international law schools coming in and participating, and Dr. Lalit Bhasin and Honorable Justice will agree that what a great job this competition has done to bring different countries together and reach out to those countries as well. A vote of thanks is by Dr. Akhilesh Kumar Khan.
Thank you, sir. Greetings and very warm welcome, respected chief guest of valedictory function, Honorable Mr. Justice Sudhanshu Dhulia, Judge Supreme Court of India, Honorable Dr. Justice Sudhir Kumar Jain, Delhi, Dr. Lalit Bhasin, President Self and Bar Association of India, Mr. Mohit Saraf, Founder and Managing Partner, Saraf and Partners, Mr. Murari Tiwari, former Chairman, Bar Council of Delhi, the esteemed organizers of the competition, Mr. Sudhir Misra, Founder and Managing Partner, Trust Legal, Mr. Manohar Therani, Dr. Mohammad Salim, Ms. Iram Majid, Honorary Director at Lloyd Law College.
Just one second, Mr. Khan.
Judges of
can all the winners
Yes,
who have
sir.
joined in, can they switch on their cameras? We'll be really delighted. We'll have great photographs there. All the winners can also join our Deputy Director and celebrate this occasion. Yeah, thank you. Please go on.
Eminent dignitaries, judges of the competition, faculty members, participants, and dear students. I have been given this responsibility to propose the vote of thanks for S.K. Misra Memorial International Mediation and Negotiation Competition. This is the 4th edition organized by Lloyd Law College and powered by Newman Law Offices, MZM Legal LLP, Saraf and Partners, Phoenix Legal, BW Legal, and Trust Legal Advocates and Consultants. It is a matter of great pride for me to offer the vote of thanks at this innovative forum, which aimed at engaging and inspiring students for the use of mediation among the young generation of professionals with a mindset equipped to effectively resolve the disputes. This academic event was aimed at encouraging the effective use of mediation and open exchange ideas among students of different universities, cultures, generations, and backgrounds. As has been informed earlier, this competition has received more than 475 registration from around 150 plus law schools across the world. And finally, top 100 teams competed in this prestigious competition over the last 3 days. We are honored today by the gracious presence of Honorable Mr. Justice Sudhanshu Dhulia, Judge, Supreme Court of India. His professional journey is itself learning lesson for all young lawyers, including us. And today also, sir has delivered a very informative and knowledgeable session, which will definitely inspire young lawyers, including me, and I hope all the people in the panel. Lordship has graciously accepted the invitation despite his busy schedule and family engagement today. We are privileged to have your Lordship as chief guest of this program. I, on behalf of all, thank you for your valuable time. I would also like to thank Honorable Dr. Justice Sudhir Kumar Jain, Judge, High Court of Delhi, and guest of honor of this program. I would definitely submit this, that in all kind of academic activities, wherever we approached Honorable Justice, he always tries to motivate us in all kind of academic ventures. Sir, with bottom of my heart and from the side of organizers, our associations and trustees, I would like to thank you for your always non-ending support to the Lloyd. Thank you very much, sir, for joining us. I would also like to thank Dr. Lalit Bhasin, President Self and Bar Association of India, and guest of honor for today's program, for his continuous guidance in all kind of academic activities and all the endeavors of Lloyd. I am proud to mention that sir has also supported us in getting 2 scholarships in Penn State University for Best Advocate Male and Female every year through our moot court competition in the name of late Professor Madhva Menon. Sir, from the bottom of my heart, I thank you for your gracious presence today. I would like to offer my sincere gratitude to Mr. Mohit Sharaf, founder and managing partner, Sharaf and Partners, and Mr. Murari Tiwari, former chairman, Bar Council of Delhi, for attending today's program as guest of honor. It is indeed a matter of great privilege and pride to get the support of such an stalwart of legal field. I, on behalf of all, thank both of you from bottom of my heart. I would also like to take this opportunity to offer my sincere gratitude to Mr. Sudhir Misra, founder and managing partner of Trust Legal, for the faith he has put in Lloyd and its student to carry forward the teachings and public service of his late father, Mr. S.K. Misra. Sir, your reason of creating a futuristic mediation culture in Indian legal landscape in mediation through the competition is definitely a landmark. On behalf of Lloyd Law, I promise we will work along in future and take my sincere Hiram Majid and Dr. Mohammed Saleh. Thank your never-ending support to our grand event. When we talk about competition, there are certain names I should take of the students who have taken their day and night from last 3-4 months. We must congratulate these people led by Ms. Daisy Pallavi, founding member and event director, Ms. Preet Kaur, student convener, and Mr. Jatin Avasthi as co-convener, along with Mr. Rishabh, Ms. Priya Bhaumik, Ms. Mimansha Roy, Mr. Randeep Singh, Ms. Anjali, Mr. Simran Moin, Ms. Akanksha. Although there are many more, I am naming all those people who are just coordinating with this competition with us very closely. Otherwise, there are almost total of 50 students organizing this competition. Now, may I also take this opportunity through this platform to announce that as we complete this 4th edition of the competition, we are also ready to announce the 5th edition of SK Misra Mediation, International Mediation and Negotiation Competition. This 5th edition will be organized from 8th to 10th March 2024. And I would like to share that 5th edition will have a lot of prize money again. With that, I would also like the team who had participated this year to please join us and also motivate your friends to join us in the next year for the competition and learn together to this new particular field of law. With this, I close my thank you all of you once again. Looking forward for your participation and support in 5th edition of the competition too. I thank all for joining the event.
Thank you.
Thank you very
Thank
much.
you. Thank you, Dr. Vasim. Thanks a lot. Thank you, Sumit. Thank you. Yeah, there is a short video I think you want to play, but
Daisy, please.
Yes, sir. I request everybody to please stay back for another 1 minute. We have a short BTS to play and honor the commitment of the organizing committee of this 4th edition.
amazing, amazing. Thank you. Goodbye. Wonderful. Well done, guys.
Thank you so much. Thank you so much, all the dignitaries. Thank you so much, all the guests. Thank you so much, all the participants. Thank you, organizing team and core committee, all the volunteers. Thank you so much. Sumit sir also from joining from Canada. Honorable Justice. Thank you so much, everyone.
Thank you. Thank
Good
you.
night.
Good night.